iWatch, you go down to tips, and you can hit the little icon for tips in the spring branch deal. Then you can send us whatever you want to send us. You can send it by email, you can send it by text. It comes to us. It also goes down to the Sheriff's Department's Control Center, where they're monitoring some of those activities.
iWatch.com or?
It's HarrisCountyIWatch.com, I believe is what it is.
iWatchHarrisCounty.com.
Right, iWatch Harris County.
And along those lines, we also have an anonymous reporting site right off the MHS website. So you can go into a anonymous site, kids, parents, anybody, and that email goes directly to me. And so you can put your name or you can make it anonymous. And so if you've got stuff going on at school that you're just trying to report, that's a safe place to do it as well. I get them every week. And then we'll farm them out, we'll look at them, we'll try to analyze what's going on. So that's another place as well.
Thank you, Lisa. Absolutely right. In another one of our schools, that's how the principal found out that there was some inappropriate conduct between a teacher and a student. Was that anonymous tip to the principal on that type of system. So it's very important to have that stuff because we need everybody's efforts on making sure that our kids are as safe as possible. Of course, there's a lot of other things that we do in the dances and the plays and the football games and things like that, but we're always cognizant of our area and making sure that if somebody doesn't look right, if it doesn't feel right, we're going to take care of it, but we ask you to do the same. If you walk in here and it's at 6 o'clock and you see somebody out driving around in a car and it just strikes you or your kids that it doesn't feel right, hey, that doesn't feel right, call us. That's what we're here for. Get in the building and get on the phone, get with an administrator if they're here, whatever, cell phone us and let us know, hey, there's this blue and white car outside, he's made a couple of laps around the parking lot, just doesn't look right. We'll come over and we'll be glad to check on it and we'll be very happy if there's something to it. So we do that. Also on the safety side of it, for this school and all of our campuses, we have extensive CCTV that we can pull up in our dispatch office. We can watch what's happening as we're sending officers. On our iPads, we can bring up the school, the camera, and we can watch it from an iPad and see if there's anything going on. So we got a lot of technology that helps us do our job too. So, you know, the main thing is safe schools, and that's what we're out here for. And we're going to be starting with a few more additional officers too that we're getting that we need desperately right now. Anything else?
I'd like to ask you to stick around because
Okay.
we'll do a little question and answer panel in just a few minutes.
That's great.
All right. Thank
That's
you,
great.
Chief Ron. We're also very fortunate to have Judge Paula Goodhart. Before being elected to Harris County Criminal Judge Court 1, she served as both the prosecutor in the DA's office and a defense lawyer in private practice. She was recipient of the 2013 Mothers Against Drunk Driving Judiciary Service Award, and she serves on the 4th Harris County Sober DWI Court. She's married to Craig, and they have a 7th grader at MMS and a freshman at Stratford. So she's in the same boat we are, folks. She just has a lot more knowledge. So, Paula, thank you.
So I've got good news and I've got bad news. Here's the good news. Statistics show that the more involved you are in your kid's business, the less likely are their chances of having some type of negative law enforcement contact or negative contact with the criminal justice system. So in other words, the more in your kid's business you are, the less likely they are to face some type of criminal consequences. The bad news is that good kids make bad decisions, and good kids exercise poor judgment sometimes. And sometimes, just like the chief said, in a moment, it can be life-altering because of their bad decisions, particularly young men. And I don't say that because I want to stereotype. I say that because statistically, in the court that I have, our #1 population is young men between the age of 17 and 25. We don't know if it's a maturity thing, if it's a brain development thing, if it's an attention thing, but statistics show that young men are more likely to get in trouble over young women. So I want to highlight some laws that your children may come in contact with over their time in high school and beyond, in college. And you need to know about these laws, and you need to also understand how easy it is for somebody to find themselves in the criminal justice system. But before I highlight those laws, I want to give you all just a little brief overview of how the court system is organized and how different offenses are classified, just so you understand when we start talking about it, what consequences or potential consequences your children face. And I have just a limited amount of time. I wish I could stay here for a couple hours and give you a long speech on all of this, but I'm going to just hit the highlights for you. All right, so in our judicial system, there are 3 different types of criminal courts. You have your Class C courts, which are your justice of the peace courts and your municipal courts. They handle what are called Class C misdemeanors. Then you have your county criminal courts, which is the type of court that I preside over, which handle what are called Class A and Class B misdemeanors. Then you have district courts, which handle felony cases. So let's get back to your justice of the peace court and municipal courts. Those are the courts that handle the Class C misdemeanors, which are typically traffic tickets. There are also minor in possession cases, or minors who are consuming alcohol, driving under the influence cases. Those are offenses where at the end of the day, the maximum punishment somebody could receive is a fine only. That doesn't sound significant, but think of it this way. Just because the offense that is being handled in that particular court is something called a Class C, and it's a fine-only offense, doesn't mean you can't get arrested for it. The only 2 things you can't get arrested for are speeding and having an open container in your car. So your child may commit a Class C offense and find themselves arrested in a police car and going to a jail or a juvenile detention facility on a Class C offense. In the kind of court that I handle, the Class A and Class B misdemeanors, somebody could actually go to jail for up to 6 months on a Class B and up to a year on a Class A. And of course, felonies are your murders and your aggravated sexual assaults and some higher level drug offenses like cocaine and meth and acid and things like that. And those folks are facing potential pen time. In Texas, at the age of 17, for criminal prosecution purposes, you are an adult. So you're going to have juniors and seniors who are going to be considered adults. So even if you are 17 and immature, if you break the law, you're going to be treated for legal purposes exactly like a 45-year-old would be in the judicial system. There is legally no difference between a 17 and a 25-year-old. If you're under 17, you're handled in the juvenile system. All right, so that's just a basic overview. Let me tell you how charges get filed. On a Class C ticket, which is discretionary with the police, because they could arrest folks. Let's say a minor in possession, particular allegation, all right? An officer has the discretion to issue a ticket for that offense to your child, and then they would be told when to go to court to handle that particular situation. Let's say, though, that they were charged with something called driving while intoxicated, which is not a traffic type offense. It is a Class A or Class B misdemeanor. If your child is of driving age, they could be charged with driving while intoxicated. Well, this is how that would work. A police officer would detain your child, would gather the information at the scene to support a charge of driving while intoxicated, pick up the phone, call the district attorney's office, which is open 24 hours a day, say, hey, this is Officer Jones. These are the facts that I have. A prosecutor on the other end of the line would say, okay, I'll accept those charges, and bam, your child is charged. And then they then have to go to court and go through the whole system. So that is how simple it is to get charged with an offense, assuming there is enough evidence to support the violation of the crime. So you need to understand that a simple snap decision, an exercise of poor judgment, could have, like the chief said, potential lasting impacts, and it could result in an actually loss of liberty. All right, so let's talk about some offenses that your kids may face, some consequences of their bad decision making, their bad judgment. Let's talk about alcohol. So we know that alcohol is the #1 abused drug among adolescents and teens. In fact, Texas has the dubious honor of holding the first place spot for #1 alcohol-related fatalities in the entire country. Harris County, now granted we are a very large county, until recently held the #1 spot for the #1 county for alcohol-related fatalities. So that's why we take it so seriously here, because we have that distinction, which is not a distinction to be proud of, all right? So let's talk about some alcohol-related offenses, because high school students do tend to consume alcohol. So minor in possession. It's a Class C offense. It's punishable by a fine only, but you can be arrested on it. So what does that mean? Well, it means that if you are a minor, which is defined as someone under the age of 21, and you are in possession of an alcoholic beverage, you have committed the offense of being a minor in possession. Well, what does possession mean? Well, it doesn't mean you had to be the one that bought it. It doesn't mean that you have to have actually consumed it, and the officers have to have proof that it's on your breath or otherwise. Possession is defined as care, custody, or control over. You don't even have to be holding it to be in possession of alcohol under the law, okay? So if a police officer sees your child in a situation and can glean from the surrounding circumstances that they had care, custody, or control over an alcoholic beverage, they have committed a violation of the law, which is minor in possession. So think about how easy that would be, all right? Minor in consumption is similar. We don't see a whole lot of minor in consumption charges because usually they're not actually consuming the alcohol by the time the police arrive. They're setting it down, right? Public intoxication. It's another Class C offense, and that is where an individual, it can be a juvenile, it can be an adult, is intoxicated in a public place. Intoxicated is not having the normal use of your mental faculties or your physical faculties because of alcohol. And if you're not driving and you're in public and you're deemed to be a danger to yourself or others, then you are considered to be in violation of the law regarding public intoxication. And the police officers will arrest you for the offense of public intoxication. And if you're a juvenile, that doesn't mean that you get to necessarily go home. Often that is the case, that the police officers will release juveniles, that means people under the age of 17, to their parents, but that is not always the case. It could mean a trip down to a juvenile detention facility. If your child's 17 or 18, that means they get a trip to the county jail or the New Harris County Sobering Center. And then you have to deal with making a bond or having them get out of jail. All right, so now you've got somebody in that situation and you go to court. And at the end of the day, the worst thing that can happen in a minor in possession case or a consumption case or a public intoxication case is a fine only. But let's say you walk in and you just pay the fine. Bam, your kid is now convicted of that offense and it is on their record. And it is there forever if it is a conviction. Now there are some laws that allow you to seal it if you're a juvenile, but if you're 17 and above, it's there forever. And it could be on your criminal history, and with the internet being what it is, it can be out there for all time. As we know, everything lasts forever on the internet. All right, let's talk about DUIs, which is different than driving while intoxicated. In Texas, historically, we only had driving while intoxicated laws. And then the legislature said, look, we don't want people under the age of 21 where it is illegal to consume alcohol, period, right? You can't drink if you're under 21, to be operating a car with any detectable amount of alcohol in their system. So we need to create a statute. So they came up with driving under the influence. So if your child is of driving age and they are under the age of 21 and they have any detectable amount of alcohol on their breath or on their person, as we call it, they are in violation of the law of driving under the influence. It is a Class C offense. It's punishable by a fine only. But this is all it would take. Your child is driving a car. They commit a traffic violation, let's say speeding. Police officer pulls them over, walks up to the window. Child rolls down the window. Police officer leans in and smells alcohol. Nobody else is in the car. The officer would say the alcohol was coming from the driver, which is your child. They are operating a motor vehicle in a public place with a detectable amount of alcohol in their system. It doesn't require a breath test or a blood test or any field sobriety test. They can be arrested on the spot. The law does allow police officers the discretion to issue a citation in that case. But with a driving under the influence charge, which is the equivalent legally of a traffic ticket, comes a lot of consequences. Because you could potentially lose your license if you've got one. If you don't have one, it could delay you actually getting a license. It could also impact your insurance, obviously, and it requires you to do a lot of community service and drug awareness classes and things of that nature. But the worst case scenario would be if your child were driving while intoxicated. That is defined as this: you're operating a motor vehicle in a public place while intoxicated, which is different from just having a detectable amount of alcohol. Intoxicated is not having the normal use of your mental faculties because of alcohol or drugs, or combination, not having the normal use of your physical faculties because of those, or having a blood, breath, or urine blood alcohol concentration of 0.08 or greater. And in Texas, y'all probably have heard this, these no refusal weekends. Not many people really understand what that means. Historically, there was the breath test that was offered to folks who were arrested for suspicion of DWI, and you could refuse to give a breath test. You could say, no, I don't want to blow in that tube. I'm not gonna give you a breath test. Well, now the Harris County District Attorney's Office has a system set up where if you're pulled over and you refuse to give a breath test, and the officers have probable cause to believe that you are driving while intoxicated, regardless of your age, they can get a search warrant for your blood. And they will execute the search warrant and they will take your blood. So you don't have a choice, and the law allows for that because it is a search of you with a search warrant. And then they test the blood and figure out what your alcohol or drug concentration was. So your children are not immune to that. I don't mean to be scary here, but we see it every single day that these people who are 17 and 18 are down in my court facing the same consequences as somebody who's middle-aged, who's made a bad decision, who should have known better. And if they're juveniles, then they're experiencing consequences in the juvenile justice system. If you are arrested and charged with driving while intoxicated, and it is your first time, and your breath test is below a 0.15, you are facing 6 months in jail and a $2,000 fine. If it's a 0.15 or greater, you're looking at going to jail for a year. And the thing about DWIs is the MAD, Mothers Against Drunk Driving lobby in Texas is so strong that the punishments theoretically are harsher for driving while intoxicated cases than they are for murder cases in this respect. In a murder case, you could get something called deferred adjudication, where your plea of guilty is deferred. In a DWI case, it is a conviction for all time. So unless you are in some type of alternative sentencing program, you will have a driving while intoxicated conviction on your record forever, and the law does not allow it to ever be erased. It is not an expungible offense. So it's serious stuff. So that's what it would take to be arrested for driving while intoxicated. All right, let's talk about parties for just a moment. It is against the law to furnish alcohol to a minor. Okay? The law does allow for you to allow your minor child, or your child under the age of 21, to possess an alcoholic beverage in your visible presence. The law allows for you to allow your child to consume an alcoholic beverage in your visible presence. It's very clear that it has to be with your consent in your visible presence. I think the law was probably written like that to allow for celebratory toasts and things of that nature. It didn't envision that a parent would endorse a situation where they have their child or their teen in their home and they think, well, my teen's going to drink anyway, so I'd rather them drink here with their friends than somewhere else with their friends. And this is where I'm going to give you all as parents a cautionary tale. So if you either furnish alcohol to a minor other than your child that's in your visible presence, or you make it available to a minor that is not your child and they're not in your visible presence, it is a Class A misdemeanor, punishable by up to 1 year in jail and a $4,000 fine. And the standard for it is something called negligence. So you don't have to intentionally furnish alcohol to a minor to get into trouble. You don't even have to be reckless about it. It's enough that you have it in your home. You know that your child and their friends are going to be there and they're probably going to drink, and you have it available for them, and you have a situation where you're just going to turn the other cheek and maybe go in the bedroom and watch TV while they're consuming alcohol. That's against the law. And you could find yourself, as crazy as it sounds, in a police car, going to jail, charged with a liquor violation, looking at going to jail for up to 1 year and having a $4,000 fine. It is serious stuff. And so when you're looking at whether somebody's negligent or not, you look to see whether or not they should have known. They ought to have known that that circumstance was going to present itself. And so you say, well, how do you know? I mean,